You don't appear to think the issue is the law. What you think the issue is the culture, right? But then what would you say? Because I would think, look, we have constitutional provisions in place for how this level of government should operate. So you do not think that the problem might emanate from the nature and structure of the existing law? Let me just quickly draw your attention.
If you look at it this way,
just before you continue, I wanted to be specific to certain provisions of the law, and maybe you can take the conversation from there. I was going to take you to sections 160 subsection 1 of the 1999 Constitution that protects the independence of INEC, which of course is the federal agency in charge of elections in all states of the federation. That section of the law gives INEC the power, the independence and powers to make its own rules and guidelines, which are not subject to the approval or control of the president. But sections 204 subsection 1 subjects the power of state independent electoral commissions to regulate its procedures and confers powers and duties on any officer or authority to the approval of the governor. Hamza, my question to you is this. By ceding operational control to governors, doesn't that amount to deliberate constitutional disempowerment of state electoral commissions? Isn't the Constitution flawed in that regard?
Well, let me look at it this way. The power to appoint the chairman of INEC resides with the presidency, right?
Yes.
So, technically,
it still gives it leverage and it gives it wiggle room to operate.
It wasn't INEC that created the law that gives that window leverage to operate. It was the presidency, and it was the citizens that, after a while of practicing the culture of democracy, they said, no. We do not want one person to appoint because it's subject to corruption, subject to interference. Can we give more powers to the National Assembly to screen and make sure that there is a check on the executive when it comes to appointment of who becomes the head of INEC? The same culture is what we are requesting for when it comes to the local government elections. We're saying that, have we tried out the current legal system and has it failed us? Because as we're speaking now, it is the state assemblies that create and formulate the laws that gives the state independent electoral commissions their powers to operate. We cannot say that the governors have interference, they interfere in those areas, unless we have done it for a while before we can now say, from looking at it, evidence has shown that this, if you leave this in the hands of the governors, they are going to. And I think I beg to differ. I try not to look at the system as bad. I try to look at the system as being, it is neither good nor bad, depending on who are those who are operating the system. We have not tried the local government system. Yes, I accept. There are laws in our constitution that does not give the state independent electoral commissions. They are just mentioned by name, and they are put under the state legislators. But it's the same way that the Federal Independent Electoral Commission is put under the National Assembly, and we are all comfortable with it. Why are we not comfortable with the SECs being under state assemblies? For me personally, I would have said, if we want to go the whole hog, we're a federal system of government, 3 tiers of government. Why should the states be asked to do elections for the local government? Why should the federal be asked to do elections for the state? Every level or every tier of government should have its own independent, self-regulating procedure for leadership selection. That's what makes you autonomous. You cannot be financially autonomous when you have another person doing the elections for you. But since we have selected that it's going to be this system of governance, fine. We know that there are flaws in the Constitution, but the Supreme Court has now made it very clear that we were looking at those flaws from our own eyes, from the eyes of the corrupt person that does not want the system to work. Supreme Court has said, no, this is the reading of the Constitution, this is how it should be. So thank God, it's the same laws that we were using in 1979 and 1999 that the Supreme Court was looking at. And it has now proven to us that we were looking at it in the wrong way. So it's not our laws, but it's how we perceive our laws. And I think that going forward, we need to begin to ask ourselves, if we truly want something, then we can see it. We can see a remedy for it, or we can see a way for it in our Constitution. I agree with you. we have constitutional issues.
Yes.